Good morning, everyone, and welcome to today's webinar. I am Chris McCauley, Benefits Attorney with ProBenefits, and I'm joined today by my fellow Benefits Attorney, Jason Cogdell. Today's presentation is a Benefits Compliance Update and a 2017 Compliance Checklist. This is the final presentation in our 2016 Client Webinar Series. We hope that the information provided in the webinars this year has been pertinent and helpful to your compliance and the compliance of your benefit plans, and we hope to provide similar content moving forward in 2017 to continue to help you with the compliance of your benefit plans. As always, a copy of the slides and a recording of this presentation will be provided to all registrants within the next couple of days. We encourage you to ask questions during this session. If you have any, you can do that by submitting them using the questions box on the control panel on the right side of the screen. We're going to try to get to as many questions as we can during the presentation. A quick look at an outline of the session for today. First, we're just going to do an update on the status of the ACA. The status of the ACA seems to be the issue that will not go away, and certainly with the results of the election, certainly it's not going away anytime soon. We're going to talk about some end-of-the-year compliance items, a look at a refresher of the IRS reporting requirements, which are due in 2017 and are still in place, and employers should that are subject to the requirement should plan on complying with. And then finally, we're going to look ahead to 2017. So with that, Jason, I'm going to go ahead and turn it over to you.
Thanks, Chris, and good morning, everyone. I appreciate your participation in today's session as well as throughout the year. Chris mentioned that questions are welcome, and they are, as he said, through the question box or separately. You can email them to compliance@probenefits.com. We really like easy questions, just to be clear. Easy questions are the best. Harder questions, not quite as welcome. I'll give you an example of a hard question. I was in the elementary school drop-off line with my second grader earlier this week when out of the blue he said, and I quote, "Daddy, do you know how many bones there are in the human body?" Well, the answer to that question was no, I did not know. And then he proceeded to tell me how many bones there are in the human body. So if you can say, you can enter this in the question box, within plus or minus 5, how many bones there are in the human body, then we owe you some type of prize. You can enter that in the question box. I'll share the answer at the end of the session. So how many bones there are in the human body, plus or minus 5. I thought that was an interesting question from him, and there may be a little twist to that question as well. So that'd be an example of a hard question. We like easy questions better. One hard question right now that is relevant to all of us is, what about the ACA in 2017? We thought we were heading into a period of status quo for 2017, 2018, and 2019 because all of the major ACA items affecting employers had gone into effect, with the last item being the employer mandate for 50 to 99 employers, which has applied for the first time in 2016. We thought we were entering a period of relative status quo. I started to say stability. Stability would not be the right word. With everything in the AC having gone into effect except for the Cadillac tax in 2020, which is, was somewhat unlikely to transpire. Then the election happened, and not just the presidential result, but also the Republicans maintaining both houses of Congress for the next 2 years. So now the question is, will the ACA stay in place? Yes or no? If it does stay in place, will the employer mandate still be the law of the land in 2017? Or will it be A, repealed, B, modified, C, left on the books but not enforced by the IRS, which is part of the executive branch, which is governed by the administration? Of course, none of us know the answer to that. It certainly looks like there will be big changes on the ACA front, but we don't know. And I won't bore you with a lot of speculation, but here's a little bit of speculation. I think the employer mandate will not last 2017, and whether that's a formal legal change or whether it's simply non-enforcement and inactivity by the IRS, I think the employer mandate's going away. And that would include not only player pay, but reporting. But having said that, it is the law of the land as of today. So I really think employers that are subject to these items, again, the over 50 applicable large employers, need to stay on course. And remember, it is the law of the land. So if we don't follow the law of the land, we accept risk. What that risk is may be somewhat undefined for you depending on your situation, but if we don't follow the law, we accept risk. So I think employers should stay on track. For example, the upcoming IRS reporting that is due beginning in February, I think employers need to proceed. There's a chance that there will be an 11th hour reprieve, but I don't think we can bank on that. So I think we need to plan to comply. So if we submit the reporting and then ultimately it doesn't matter because it's not enforced, then that'll be a after the fact reprieve. But I don't think we can back down from these requirements yet. And so my speculation is that there's going to be change, but it may take some time for that to happen. For example, if there's going to be a new ACA, a new healthcare reform law, that's going to take likely 1, 2, maybe 3 years for Congress and the White House to put that together. There's a very good chance that the ACA in its current form may be dismantled or replaced very slowly rather than very quickly. So I think we need to keep that in mind. Stay on track, employers, for compliance in 2017. That's my personal speculation and best practice advice. What we're going to do is look at some end of the year compliance items based on what we know right now, look ahead to 2017, acknowledging that there are going to be things in 2017 that we don't know about, just as there have been 2016 developments that we don't know about, and then we'll share a couple of updates as well. 4 quick end of the year compliance items, some of which may not apply to your organization. First, 2016 is the last of 3 years of the transitional reinsurance fee. This is the fee that started off as the $5.25 per participant per month fee that applies to all plans. But self-funded plans have to file with the government directly because fully insured plans, the fee is taken care of by the carrier. So if your organization sponsored a self-funded major medical plan for all or part of 2016, and this would include the so-called level funded plans, which are really self-funded plans in terms of compliance requirements, then the fee needs to be filed. The first step is the participant count, which must be submitted at pay.gov. Hopefully those of you that sponsor self-funded plans are not hearing about this for the first time. The deadline for the participant count was actually November the 15th, but many employers have missed that date. If it hasn't been submitted, it needs to be submitted ASAP, and then that starts the process of paying the fee, which is also done by virtue of pay.gov, which is a federal government site. This fee is designed to expire after this year, and hopefully that will be the case. It hasn't been extended as of yet. My thought is it will not be with the current Congress. And also, just to clarify, HRAs and FSAs are exempt from this fee. So whereas HRAs have to pay the PCOR fee in the middle of the year for plans that ended in the prior year, HRAs do not have to pay. This is only a major medical fee. For fully insured plans, you don't have to worry about it. The carrier is taking care of it. Self-funded plans have to do it unless your TPA has handled it. So that's end of the year compliance item number 1. Compliance item number 2, updated SPDs. If you have a calendar year plan, whether health plan, dental plan, vision plan, Section 125 plan, whether that's just for pre-tax premiums or it includes FSAs, if you have an HRA plan, if you have any other type of benefit plan, and the plan is changing for 2017, you need to make sure that the summary plan description is also updated. And that's something that, for example, we at ProBenefits assist with for FSA, POP, HRA plans that we administer, helping update those SPDs. But that would also apply again to the group health plan. One quick example, a question that came up earlier this week from a client. Client had made the decision to allow not only common law employees to participate in their health plan for 2017, but also 1099 contractors, and the carrier had approved this. Question from the employer, what do we need to do? And the answer to that is, after they've gotten carrier approval, they need to make sure their SPD allows that those 1099 contractors to be included, because we want to administer the plan consistent with the SPD. So that's an end of the year compliance item. Also, SBC, summaries of benefits and coverage. Those, pesky SBCs for the group health plans still apply. That requirement hasn't gone away. We're supposed to be providing updated SBCs at renewal if the plan has changed for the new year. So keep in mind that that's a collateral requirement as well. And then also for employers that sponsor flexible spending accounts, health FSAs, the maximum has increased for 2017 plan years to $2,600. It was $2,550 for the last 2 years. And so employers that want to utilize that maximum, they may or may not need to change the document. For example, we draft our FSA SPDs to automatically include the maximum if it goes up from IRS indexing. But you'll want to make sure you take care of any adjustments if needed for your participants. Similar for those of you that have qualifying high deductible health plans and your employees have health savings accounts. You want to know the new maximums to make sure that your employer contributions plus any applicable employee contributions are within those maximums. Chris, anything to add on the issue of maximums for FSAs or HSAs or any SPD changes for 2017?
One point about the FSA max, that is for plans that begin 1/1 or later, 1/1/17. So sometimes we have some December 1 plans that have asked if they could increase their plan max for the December 1, 2016 plan year. Unfortunately, they have to wait a year in order to do that. So the plan max just goes up for plans starting 1/1 and after. And in terms of updated SPDs, some other common updates are common plan changes that would require an update include eligibility changes or a plan year change or a plan design change for an HRA. So those are just a couple of the common scenarios where an update to the SPD would be required.
Thanks, Chris. Now, if you see these end of the year compliance items and you think, great, we don't need to do anything new, we're in good shape, fantastic. But these are just the items to keep in mind both for the end of this year and the beginning of next year, particularly for calendar year plans. The same concepts apply for plans with on a non-calendar year basis, the so-called fiscal year. Keeping in mind that the transitional reinsurance fee, the same deadlines apply for all plans, regardless of the plan year basis. And as Chris said, the IRS maximums for FSAs and HSAs apply to accounts in 2017, whether those are 1/1 or 2/1 or 4/1 or 7/1 renewal plans. One update, this is not an end of the year compliance item, but one update that you may have read about is that the new law that was passed last week, the 21st Century Cures Act, which is a major piece of legislation passed by Congress, signed by the President this week, is about much broader issues than benefit plans. And there were significant items related to cancer research and funding, medical devices, and many things that affect the healthcare industry. Included in that law was a new option for small employers, the so-called qualified small employer health reimbursement range. So this is just a type of HRA under IRS section 105. This was actually part of some separate proposed legislation that ended up being rolled into this 21st Century Cures Act. But I wanted to say just a brief word about it because it may be something that may be an option for some of you that are small employers, particularly very small employers that either do not have a group health plan now or may not have one at some point going forward. I listed on the slide Back to the Future because really these small employer HRAs are not so much new as really something that employers used to be able to do that the ACA took away, because the ACA beginning in 2014 required any employer that wanted to have a health reimbursement arrangement to have a group health insurance plan. So for 2014, 2015, and 2016, the only employers that legitimately had an HRA, such as a deductible reimbursement plan or coinsurance reimbursement plan, use that HRA in conjunction with a major medical plan. That's what the law has said for the last 3 years. But before that, pre-2014, employers could sponsor HRAs, employers of any size, and the HRA was funded by the employer, and it could reimburse any eligible out-of-pocket medical, dental, vision expense, including individual health premiums. So what employers could do pre-2014 is being restored, but only for small employers that are not subject to the employer mandate. So to be able to use this small employer HRA, the employer cannot be an applicable large employer subject to the mandate. So it has to be a non-ALE. So that means an under 50 employer that is not part of a control group subject to the mandate. These employers, if they fit that eligibility definition, and if they do not sponsor a group health insurance plan, may use this employer-funded account up to certain maximums as listed on the bottom of the slide there for individual coverage and for family coverage. And the account can fund out-of-pocket medical, dental, vision, including individual health premiums. So this is a new / old option that's being restored for small employers. The idea being for employers that are not required by law to provide a group health plan, the applicable large employers under the mandate, these small employers should have the option to use some type of cost-effective option in addition to a group health plan. So how many employers will use this, we don't know, but it is an option for small employers. Now, pre-2014, the small employers that were using this were primarily very small employers, in the range of 10 or fewer employees that did not have a group health plan, and primarily nonprofits and churches. So will those employers go back to this type of arrangement? Possibly. Will many groups use this? We don't yet know. It is something that we can administer. It is something that we can provide more information on if it would be something that your organization is interested in. But we just want to brief you on this since it is a very new development, again, passed just last week. So employers can use this in 2017. The law allows the effective date of these plans to be as early as 1/1/17, and there are other compliance considerations. As one example, a common question this week has been if the small employer utilizes this type of arrangement and sends individuals out to the individual market or the marketplace, can the individual still be eligible for a federal government subsidy at the marketplace? The answer is yes, but there are some qualifications, and in many cases, this small employer HRA will disqualify the individual from subsidy eligibility. It's not a blanket yes or no. There's a formula involved based on the cost of marketplace coverage and affordability, but in many cases, subsidy eligibility will be nullified by the small employer HRA. The other question, could the HRA reimburse the employee's coverage under a spouse's group plan? And the answer to that is no, because the spouse's group plan is being paid by that spouse with pre-tax dollars, and so it can't be reimbursed tax-free to this employee. There are many other, or not many, but there are a few other important compliance considerations we'll be happy to discuss with you, but that is the gist of the new small employer HRA, which we'll be providing more information on soon to both advisors and employers. But if it's something you'd like to discuss as an option for your small group, we'll be happy to discuss with you. As another update, as we look into 2017, beyond that one new item that only affects a subset of employers, something that affects many employers is the ACA reporting requirement, which, as I mentioned, is still the law of the land, and I think that employers need to continue to prepare to comply beginning in February. Some of you may have read that there was a recent delay in the reporting requirements. The only delay, as listed down here in the fourth bullet point on the slide, is that the employee statement, the 1095-C form that applicable large employers have to provide to any individual that was full-time for all or part of 2016, would have been due on the W-2 deadline January 31st, and the IRS has delayed that to March the 2nd. So employers get a month and a few days extra to provide those employee statements in hard copy or electronically to individuals that were full-time in 2016. the IRS submission deadlines for the 1094-C. The 1094-C is the form that has to be provided, one copy per tax ID to the IRS, along with copies of all the employee statements. That deadline was not delayed. So that deadline is February 28th, 2017, if done in hard copy, or March the 31st, 2017, if filed electronically. So good news, employers have a little bit more time with the employee statements. Bad news, there is no delay, and that leaves only roughly a month between the inauguration and Congress taking or starting the new 2017 congressional term before these deadlines are set. Could there be a reprieve at some point between the inauguration and the end of February deadline? Absolutely. Can we bank on that? I don't think so. So the way I feel about it is, this is the homework for employers. It may be that you turn in your homework in February, and then the teacher tells us later, I'm not going to grade it, I'm just going to stamp it all approved. That may happen, and if so, great. But I don't think employers can afford to not report unless and until that reprieve is granted by the government. So that's where we are. I'm not going to say any more words about the reporting right now. If the reporting is something you're doing yourselves internally, great. A lot of employers are doing that with success. I think you certainly need to understand the reporting to do that, but it's something employers can do. If you're outsourcing, great, but keep in mind, you employers are going to need to review the forms before the employer signs off on them and submits them to the government. So hopefully we're in a lot better shape to do the reporting in this year, the second round of the reporting, but it is still in place and is something that applicable large employers need to do, as well as small employers that had a self-funded plan or a level-funded plan during 2016. Those employers are required to comply with a very limited reporting obligation for the B series, 1095-B to employees that enrolled this year, 1094-B to the government. Otherwise, only applicable large employers are required to do it. So that's just a quick word about the first scheduled significant compliance item in 2017. The plan for this webinar was to share with you the 2017 compliance checklist. We typically provide a basic compliance checklist in writing for employers and advisors to use during the plan year and build upon based on your specific situation. What we decided to do, given some of the uncertainty today, is not to provide that checklist. We will provide that with an upcoming compliance update in early 2017, but we wanted to have a little more time to prepare that checklist for you. I'll give you a preview of it, and this is the preview, with item 1 being the player pay requirement and the reporting requirements, assuming they stay in place, and that's why those items are listed in italics there. I think the number 1 non-ACA compliance requirement of 2017 is HIPAA, and I mentioned this or Chris has on prior sessions, but HIPAA is an enormous topic, and I do not expect those requirements to change in 2017, even if there's some ACA changes. So HIPAA compliance for employers and advisors, and yes, there are compliance requirements that apply to insurance agents and advisors. I think those privacy and security rules will be potentially the number 1 compliance item of 2017 if the ACA is modified or not enforced. So HIPAA is going to be a big deal in 2017, as it has been, frankly, in 2016. More to come on that subject. Next, and just to reiterate, particularly if the ACA changes in 2017, but even if it doesn't, some of the basic bedrock requirements for benefits compliance need to be addressed by employers. This includes ERISA compliance. This includes COBRA. By the way, one of the most significant, if not the number 1 compliance item that our team has dealt with in 2016 is COBRA. Employers that didn't have a good COBRA solution, employers that were not offering COBRA for all eligible benefits, employers that didn't even realize that certain benefits they sponsored were subject to COBRA. The COBRA market has changed a lot as a lot of the discount carrier-driven type solutions have gone away. Carriers have tried to largely get out of COBRA. Fewer payroll services are doing COBRA, especially if they weren't doing it very well. Frankly, our COBRA business has grown substantially. We are administering COBRA for employers of all sizes. We're administering COBRA for all required lines of service. We have an advanced COBRA team that really knows what they're doing. We not only do the required notices and the optional notices, we even get involved to assist the employer if there are appeals regarding COBRA coverage. And our goal is to handle COBRA for the employer stem to stern. So if that may be a consideration for you or something that makes you nervous and you need some sleep insurance on that, let us know. This is something we can provide. It's a very inexpensive service, but a very valuable service for employers, and something that has been a big part of our business in 2016 and will certainly be in 2017. Also, another basic requirement, just the basics of IRS benefit plan rules, something Chris and I deal with all the time. Employers that are pre-taxing for benefits but don't have a Section 125 document in place for pre-tax premiums. Employers that may have sponsored a flexible spending account or allowed employees to use health savings accounts but are not following some of the basic IRS rules that protect the tax-free nature of those benefits. Those type of back to the basics issues are important as employers protect what they're doing now and going forward without any concern of any adverse tax consequences. There are other items on the checklist as well. For now, I'm going to leave it at that, other than saying, again, none of us have any idea what will happen in 2017, what will happen, for example, with the new FLSA overtime rules. Will they take effect in 2017? Will they be changed? Will they be wiped out altogether? What impact will that have on benefits? What impact will the minimum wage changes of 2016 and potential modifications in 2017 have to employee benefits? There are a lot of unanswered questions, and that is something we'll just need to track carefully and be ready to adjust as we proceed in 2017. So again, our plan is not only to stay on top of these items and to communicate with you the best we can, but we plan to provide that compliance checklist likely in January, sometime in the middle to late part of the month with you by a compliance update, and that's what our commitment is to you to help you proceed. Another quick word about tools. In addition to the compliance checklist, we certainly plan to continue our webinars and compliance updates. We work hard to provide helpful, practical one-pagers on key benefits topics, and that's something that we largely provide to our active clients and the advisors that refer business to us. But if you have a particular interest or need, let us know and we'll see what we can do to help you. We have a number of customized options, including providing training sessions for employers and advisors and organizations, and we've got some advanced compliance options as well. So feel free to contact us if something along those lines may be helpful. Before I say a word about best practices to conclude, and we'll hang around a little bit to answer some questions. Chris, any questions issued through the question box that we need to address before we go farther?
Yeah, I think there are a couple here we can address pretty quickly. The first one is for POP plans and whether they need to be updated every year or only when there are changes. Generally, POP plans and SPDs, ERISA SPDs in general, only need to be updated and provided to participants when there are changes. Documents, SPDs that don't have any changes are generally effective for up to 10 years as long as there are no changes. So if there are no changes to the POP plan, then new SPDs don't need to be provided each year. There's another question about COBRA, and it said, other than medical, dental, and vision, what other benefits are COBRA required? COBRA applies to group health plans. So in addition to those medical, dental, and vision benefits that were listed, other plans that generally fall into those categories include FSAs, HRAs, some cancer benefits and other disease-specific benefits could be COBRA benefits. Also, potentially, depending on the types of benefits they offer, telemedicine or on-site clinics could potentially be COBRA benefits. Jason, one other question about the small employer HRAs and whether they could be offered to employees if the employee waives the group health plan.
The answer to that is no. The small employer qualified HRA plans that are based on this new rule can only be offered by an employer that does not have a group health plan. So if we've got an under 50 employer and that employer offers a group health insurance plan for any employees, even management, that employer is ineligible to sponsor the small employer HRA. So it's only going to be for those employers that do not have a group health plan and are not applicable large employers. And that's one reason I expect this to be primarily used by very small employers. Before the law changed in 2014, we saw these type of so-called bucket of money HRAs provided by employers of various sizes, but they were heavily used in the 10 and under employee segment. My guess is that's still where the majority of employers will be, because the large employers get closer to 30, 40, 50, the more likely they are to have a group health plan, or frankly, the more expensive these plans get to administer, because if you're going to, not administer, to sponsor, because if you're going to provide a meaningful amount of reimbursement on a monthly and annual basis for 30, 40, 50 employees, that comes with a price tag. But if the employer sponsors any group health insurance coverage for any employees, then it would be ineligible to sponsor the qualified small employer HRA.
We have one question about our administration of COBRA and whether we only administer for plans subject to COBRA, so 20 or more employees. And I would say in general, yes, we are only administering COBRA for the employers and plans that are subject to COBRA. The reason for that is often the state continuation rules, the rules that may apply to small employers under 20, often don't have the same stringent reporting requirements or disclosure requirements to participants, notice requirements. So often the employers themselves can handle state continuation. So in general, we are only administering for COBRA for over 20 plans with over 20, or employers with only over 20 employees.
Yep. Well said, Chris. And one of the follow-up questions was about dental. First question, is dental a COBRA benefit? Yes. As Chris said earlier, anything that's a, quote, group health plan, end quote, under the law is subject to COBRA. That would include group dental plans, group vision plans, or any supplemental health coverage that's a group health plan benefit. For instance, health reimbursement arrangements are subject to COBRA. By the way, the new small employer HRA is specifically exempt from COBRA and ERISA, which is a surprising development. So that's COBRA does apply to dental and vision and supplemental health plans for COBRA eligible employers, but in this case the question was asked by an employer that has less than 20. Most of the time, it varies by state, but most of the time state continuation laws only affect group health coverage. That's the way it is here in North Carolina. Only major medical coverage is subject to state continuation. So dental, for example, would not be subject to state continuation, but it would be if it were a COBRA situation. In the interest of time, I'm not going to say any more about these back to the basics topics and best practices for 2017. We'll provide you a copy of the slides, and if you'd like to have any further information on those items, feel free to let us know. What we're going to do now, I'm going to share the answer to the question about the bones, the teaser from earlier. But what we're going to do now is shift into a question segment. So for those of you that need to go, you're welcome to go. We wanted to let you go after 30 minutes. And we will hang around for about 10 minutes and answer some more questions if you have those submitted to the question box. Before I do that, the answer to my son's question about bones in the human body, and a number of you got this right, or very close, within plus or minus 5. The answer was, according to at least to my Google research, was 206, that adults have 206 bones in the human body, or the average human does, with the very interesting twist being, and this was a surprise to me, that humans are generally born with approximately 300 bones, and then as they grow from babies to toddlers to young adults, that number decreases to 206. So 206 is the magic number. Congrats to all those of you who said between 200 and 210. Well done. A lot of correct answers there. Thanks for your time today. Those of you that want to hang around and submit a question to the question box, Chris and I are going to hang around and answer those for approximately another 10 minutes. For those of you that go, thanks for joining us, and certainly want to wish a word of Merry Christmas and Happy Holidays to all of you. Thanks for joining us today.